Area Plan Commission public hearing agenda at petitioner's request, placement thereon being without reference to compliance or non-compliance with the adopted subdivision ordinance. S. 5075 Wabash Ridge Subdivision Major Preliminary.
I second.
All in favor?
Aye.
Opposed? Motion carries.
I move the following rezoning petition be placed on the June 15th, 2022 Area Plan Commission public hearing agenda. Z. 2860 Richard and Gail Michael, NB to NBU.
I second.
All in favor?
Aye.
Opposed? Motion carried.
I move the following petitions be placed on the June 2nd, 2022 Area Board of Zoning Appeals public hearing agenda. Those would be BZA 2079, William S. and Jacqueline Bond, BZA 2080, James Allen and Tracy Barton, BZA 2081, Patrick R. and Melinda C. O'Neill, trustees of the Patrick R. O'Neill and Melinda C. O'Neill Revocable Living Trust, and BZA 2082, Riverside Construction, LLC.
I second.
Just as a correction, you said the second, June 2nd, June 22nd.
My apologies, I correct that to the June 22nd, 2022 Area Board of Zoning Appeals. Thank you, Larry.
All those in favor?
Aye.
Opposed? Motion carried. Determination of variances.
I move the following requests for variance from a unified zoning ordinance are not requests for use variance prohibited from consideration by ordinance and statute. Case 2022-14, Jasmine Jones and James F. Oles. Case 2022-15, Anthony Hardebeck, and Case 2022-16, Sinorama.
I second.
All in favor?
Aye.
Aye.
Opposed? Motion carried. Review of the May budget report.
I move we approve the May 2022 budget report as submitted.
I second.
Mr. Hiddle.
Thank you. The budget report is included in your packet. I'd be happy to answer any questions you might have.
Any questions? Hearing none. All those in favor?
Aye.
Opposed? Motion carried. We have no other business. Mr. Schroeder,
I move we adjourn.
we're adjourned.
So I will call to order the Area Plan Commission of Tippecanoe County Ordinance Committee meeting for June 1st, 2022. And first on the agenda is approval of the minutes.
I move we approve the minutes of the,
I'll lose my job.
the April 6th Ordinance Committee.
I second.
So we have a motion and a second. Any comments? Hearing none, all those in favor say aye.
Aye.
Opposed? That motion carries. Second on the agenda, towing, impound, and lot amendment.
Good evening. David Hiddle with the Area Plan Commission. This is a proposed ordinance amendment that we're calling a fix to the ordinance It would allow for towing service and impound lot use by right in the I-3 district. We have 3 industrial districts, I-1, I-2, I-3. I-1 is the least intense, I-3 is the most intense. And for some reason, I-1 and I-2 allow for towing lots and impound lots and towing services, but I-3 does not. We don't know why, and it doesn't really make any sense. We had gotten a phone call about a particular site that was zoned I-3. It was an impound service that wanted to locate there, and we said, well, the ordinance doesn't allow for that. And again, we're not sure why, so we kind of think it's right-sizing it or fixing it to allow in the most intense industrial district for impound lots and towing services. And that's what this would accomplish. Any questions?
Any questions, comments? Anybody from the audience wish to speak? Hearing none, I guess I would entertain a motion that we send that to the full Plan Commission with a recommendation of approval.
I'll make the recommendation to submit, to move it ahead, sorry. As submitted.
Okay? So we have a motion and a second. Any other comments on that minor fix to the ordinance? Hearing none, all those in favor say aye.
Aye.
Opposed? That motion carries. Thank you. Number 3, zoning enforcement amendment.
Thank you. We've been speaking with the building commissioner, and specifically the building commissioner, Mike Wolf, who's here. I think it's been a number of years, many years, under a different set of commissioners that the task of enforcing the zoning ordinance was shifted from the APC to the building commission, which is an unusual place for it to be because the inspectors are well-versed in building code, but not in zoning code, and typically enforcement of the zoning ordinance falls under a planning department. So I've been speaking with Mike, and it seems, and with Tom, and it seems the better house for enforcement of the zoning ordinance would be the Area Plan Commission. We're the folks that are dealing every day with the zoning ordinance. And at the same time, it's an opportunity to look at the ordinance, the enforcement language, and tighten it up a little bit to make it more impactful, give it more teeth. What's happening today is that a zoning complaint is received, and Mike or one of Mike's inspectors will go out, identify if there is or is not a zoning violation. They'll write a letter, and if there's no action, they'll write a second letter to the property owner saying you're under violation, you need to do this and this and this to make it right. And then if there's no, if they don't cooperate and fix whatever the problem is on the property, then we transition it to external counsel, legal counsel, which is pretty time and resource intensive as far as zoning enforcement goes. I think most ordinances allow for it to be more of a staff process, more of an administrative task, where the burden of fixing the thing is placed on the property owner rather than on the county or municipality or whatever. So this would give staff the ability to make the determination that there is a violation in place. It would give them the ability to issue a letter, which, and then the letter tells the property owner what he or she must do to fix it, what his other options are, and then the penalties that he or she will incur if it's not fixed, and the order that those penalties will occur. And then it never will involve external legal counsel unless it cycles all the way to the end, and it's determined that we need to bring in legal counsel to bring the matter up in court. So the way it's currently configured, really the first thing that happens is that Eric or Alex Burns will take it to court, and it can spend a lot of time there. And I think Tom and Tracy can attest to the number of phone calls they receive while it's sort of in limbo in that position from neighbors who are not getting satisfaction. So This is actually modeled after, and I think improved upon, an ordinance we put in place when I was in Johnson County that one of the primary tasks I was given there was to give the enforcement procedures teeth so that we wouldn't have these legacy zoning enforcement violations that just stand year after year. It worked well, and so I've adopted it for use here. The summary is in your packet on page 10, and then the red line version is on pages 13 through 16. Now, this zoning ordinance, this enforcement language, will be that which is used by the county, West Lafayette, Lafayette, and the smaller municipalities. So we had to make the language suitable for everybody. West Lafayette and Lafayette have their own enforcement bodies, and in Lafayette's case, they're pretty pleased with it, and they didn't want much to change, so we didn't really change the language. We just added language to it, and kind of gave them an additional tool, so they're comfortable with it. I think West Lafayette is more interested in maybe availing themselves of this new language, this new enforcement, so they're comfortable with the language as well. So it's, I think, satisfactory to all the people that have to use it. And again, I think it's going to give us a little bit more teeth. It's going to make property owners pay attention a little bit more quickly and bring some satisfaction to their neighbors. When we're talking about zoning violations, what we're looking at is mostly the accumulation of junk on residential properties, usually in rural areas. Oftentimes, there will also be the development of a literal junk lot for commercial gain on these properties. Sometimes it'll be the accumulation of building materials and heavy equipment if somebody's operating a contractor out of the house. Those are the two primary ones, with the accumulation of junk, debris, scrap being the primary violator. And I think that's what we found in Johnson County. I think that's what you find in a lot of other counties as well, especially in rural areas. We will not need, I think, to add any more staff. In speaking with Mike, there's about 60 cases per year, 60 legitimate zoning violation cases per year, which is one per week. And we will maintain a hybrid relationship with the building commission so that their field guys will continue to be our field guys. They'll be the eyes in the field. They'll do the first investigation after a complaint is received, take photographs, bring that information back to us. But then instead of them having to write the letters and deal with the neighbors and deal with the property owners, that'll be our duty to do that. And my experience is that one per week is not a significant upgrade in terms of time sapping activities. So we'll be able to manage this as we are currently constructed. And be happy to answer any questions you might have.
So, David, the changes that you proposed here, those have all been vetted through the different entities, correct? Meaning you've done that at the administrative officers meeting?
Yes,
Okay.
and then we had a specific meeting with Lafayette and West Lafayette and their enforcement
Folks, okay.
officers to talk about it. And then as we get through the ordinance committee and then get it into the plan commission, and in the event there may be some language changes, we'll put it back out to them for a final
Okay.
approval.
Cool.
I
Go ahead.
was just interested in your experience at Johnson County, how these get resolved. It appears that you find them and then it goes on their tax bill to be paid. And what's your experience with that? Do you get people compliance? Because I have had discussions with the county inspectors, and some people are just pretty defiant. They're just not going to do it.
Right.
But you find this, I just want to know your experiences.
We issued property liens on average 3 times a year, probably. It got to that point only 3 times a year. Most of the time, once they see that they're accumulating a pretty significant daily fine, and they see that where it leads, they're spurred to action of some sort. We also intentionally leave a lot of leeway at the beginning to negotiate a remedial plan. So you're dealing a lot with hoarders, people that maybe there's even a psychological or mental issue in place. And so you don't want to say, okay, your property is a junkyard, you have 2 weeks to clean it up. After that, $50 a day, and it's going to double after a month. You give them the benefit of the doubt at the beginning, and you can come up with a written plan that allows them a month, 2 months, 3 months, 5 months, 6 months, depending on what you feel is going to be needed, so that they're not put in an impossible position. Once we changed the ordinance and a couple liens got put on properties, some of those legacy violators did take note, and then they took action to clean up their properties. But that's certainly not what you want to do. You're not doing it to get the revenue. You're doing it because it's the money that speaks to people, I think, as a penalty. I would say that probably a third of the property owners utilized the option for a negotiated remediation plan, and that was pretty much always an extended timeline. And you learn how to write those. They need to be specific by September 1st. You need to have the 3 trailers out, and by November 2nd, you need to have, the rusted out tractor away and things like that. So it's not interpretable in different ways. So I don't know if that answers your question, Gary.
It does. No, I know it's a frustrating thing for the building commission. And maybe it's in here and I missed it, the appeal process, if they have a determination, does
Yeah.
that kind of stay the same, or did you rewrite their appeal process?
When they get the zoning violation letter, they have a number of options. Number one is they can fix it. If it's a junk property, they can clear away the junk, for example. Second, they can file for a whatever land use petition they would need to legally establish it. So if it's a literal commercial junkyard, they could file for a rezoning to rezone the property to that zoning district. Often not the best route. They also have the option to appeal it, and that would take it to the Board of Zoning Appeals. And by appealing, they're saying, I believe that you have wrongly issued this violation. I believe that the property is not in violation. In that instance, and we already have this appeals process, essentially appeal of an administrative decision, that goes to the Board of Zoning Appeals. They would hear the case. It would be a public hearing just like would be a variance. They would hear from potential remonstrators, they would hear from the property owner, and they would hear from staff, and then they would either approve or deny the appeal. Also, if they do file a variance or something to legally establish the violation, whatever it is, and it's denied, we would also ask then the Board of Zoning Appeals, in that case, for guidance at the end of the hearing as to how much additional grace period should be given the property owner before enforcement continues. That way, everybody that's concerned is in the room when that decision is made, and that would be the property owner, usually neighbors and staff, and that works well also.
Is the appeal process in this document, or is it separate? And is it here and I missed it?
For the appeal?
Yes.
Yeah, it's in there.
I thought I saw it, and then I can't find it.
I mean, the appeal process is already spelled out in Chapter 6
Yeah,
of the
it's
UZO.
page 14 in the middle of the page, B3.
Thank you.
And like Ryan just said, if you file that formal appeal, you're taken to the process that's already described in the zoning ordinance for an appeal.
What page did you say? 14?
14.
Page 14,
B3.
B3. I got it. I even got it marked there. Okay. So what is the cost to file an appeal?
It's $500 flat fee.
Do those go to or to this board currently, ABZA
Yeah, it goes to the Board of Zoning Appeals. Here's those.
currently?
Yes. And we hear very, very few. I can remember maybe one in 20 years. And that was a billboard on the West Lafayette, a determination. So they don't come very often. except 20 years ago when we had an aggressive zoning enforcement officer that was writing many violations. There was many of them filed, and I think maybe, I don't know everything, but maybe that's the reason the procedure was changed, because it wasn't not working very well. So-
Lots of appeals of issued violations.
Yes,
Interesting.
yes, because of aggressive enforcement, I guess you could say. It wasn't
Okay.
done on complaints, it was done on somebody driving around and
Okay.
saw something, wrote a violation, and there was lots of appeals. So I think that changed it, and I think this system works well if you have the right people in place.
Mhm.
I think it's a great program, and you understand you have to encourage people sometimes to
Yep.
correct. And I know Building Commission does that now. They
Yep.
work very well with people, but sometimes it's just hard to get people to just say, I'm not doing it, make me. And, somehow you need to do that without being too cumbersome, giving them an opportunity. The thing, we changed the appeal once on something. The cost just seems high, $500 to file an appeal. Because if I made the argument before, if I get a speeding ticket, I can have a jury trial, it costs $0
Yeah.
as an enforcement, or a parking ticket, I can have a hearing. And I'm not saying it should be $0, but I'm wondering if maybe $100 would be more appropriate. Not that I'm just going to file one, but if I think I have a legitimate case and I'm going to bring real evidence, I'm open for suggestions. That's just my thought of not being too cumbersome on the citizens. Maybe sometimes people just want to be heard.
What?
You know.
I don't even know. What is our procedure for a request for a waiver or a refund or a reduction of filing fees? Is there anything?
No.
Nothing?
Yeah, the other thing you could do is, and this isn't unusual, is say, and if you win, you get it refunded.
Right. That would
Which-
make sense.
Certainly helps.
Yeah.
But 500's a big number.
It's a common fee. It's a rezone petitions, 500.
Yeah,
It's-
absolutely,
We
and
sort of,
it
it's a
mirrors
flat,
that
across-the-board
completely.
fee.
It's across the board,
I mean,
you're
I
right.
think it was $100, and then in 13 or 14, we reviewed the fee schedule against other localities all over Indiana, and found we were a bargain compared to many peer communities, and so we
But when
made some
we
adjustments.
did that, this wasn't falling underneath there, correct?
It was there. I thought it was too high then.
Oh.
I thought it was too high then, I couldn't.
I mean, I remember when we went through all that.
Yeah. Just for someone to
Yeah, I agree.
appeal
It's a lot of
their
money
case.
if it's-
For some people. If somebody's petitioning for a BZA special exception or variance, they're initiating the action. In this case, somebody's initiating the action against me. And I say, I think you're wrong. But it cost me $500 to have someone hear my case.
Could be $0. In Johnson County, my experience is that there was less than one appeal per year.
We haven't had many.
Yeah.
But was there a fee to appeal that?
There was technically, just like here, it fell to a flat fee, which was $200, but there was also an option to request a waiver or a reduction of that fee,
Okay.
which you could do to the body that's hearing the petition, and that was done frequently. And we usually supported it. But that's not in place here,
Yeah.
so.
I'm open for ideas. If somebody has something up other than mine, I think 500 is too high. I don't know that it needs to be $0, $50, $100, I don't know.
I mean, there's going to be so few of these, because, even if, if it goes that far, it's pretty blatant, wouldn't you think, of a zoning enforcement issue?
Yeah, we wouldn't issue the violation unless the evidence is heavy in favor of the violation. So there's
I would be more in favor, just so they're not fragrantly filing appeals, have it being waived if they win the appeal. Or refunded at that point.
But the $50 fee keeps accruing every day, even through my appeal process, correct?
No,
No.
if you file an appeal or a variance or whatever to make it legal, then all enforcement is put on ice until that's decided.
I don't know, it's a fine line. I agree with everything that's been said, but $500 to some people is a lot of money. But I appreciate it needs to be high enough that, like, it's not so easy, I'm just going to appeal to go through the motion.
So for discussion purposes, I'll make a motion that we reduce that fee to $100 to file for an appeal of a zoning violation.
That's a separate ordinance, right? We'd have to amend that.
Well, yeah, that's, the bylaw committee controls the fee schedule, so you're essentially requesting that the bylaw committee
I want to get
check
on the
that
floor
out.
and discuss it kind of more in depth. We've
Mhm.
kind of beat it around the bush. So if I get a second, we'll discuss it. If not, it'll die.
I think it should be a tad higher.
Pardon me?
I think it should be a little higher.
I do too.
What do you think it should be? 200?
I was
Okay.
going to split the difference and say 250.
That's what I was going to say, too.
I can go with that.
I'm with Vicki.
There's-
250.
well, that's why I wanted a motion on the floor. So I'll amend my motion to 250, hearing some comments. I'll amend my motion to reduce the appeal for a zoning violation to 250.
I'll second that.
Okay, so I have a motion, a second, to reduce that, however that's done. If that goes to the bylaws committee, I guess it would be a recommendation.
Who is the bylaw committee? Is it the same as ordinance, or is it a different committee?
It's very similar.
It's very similar,
a-
maybe another.
It's a hybrid of
Is it?
multiple committees, yeah. So it doesn't assemble very often, so yeah.
Is that the one combined with personnel?
Yeah,
Is it personnel and bylaws? Okay.
correct,
You-
yeah.
Ryan, we usually don't, ordinance and bylaws usually combine
I
to
was thinking
Yes.
I did.
have a meeting, yeah.
Invite him next time.
Yeah.
Who
So-
else is on that? I don't have that list.
I don't have the master list, yeah. We've got it
Any
somewhere.
any
I have
other
another
discussion? Okay.
I appreciate under timeline, and I know this is how the world works as far as mailing, but this becomes a greater issue every day.
Yeah. Let's finish this
Okay,
motion
sorry.
first, then we'll get to
Okay.
that. So I have a motion. Any other discussion on reducing that to 250?
So the motion is actually a recommendation to the bylaw committee. Is that correct?
I don't know. I would say that I guess we don't have the power to do it. We could write it in this and make the bylaw committee do it, just as long as it gets done. I guess we could do that. Technically, how do we do
I
that?
think it is a recommendation to the
Okay.
bylaw committee,
It's a recommendation.
and maybe you invite them to attend next time.
If we can put
Next
that on the
meeting,
agenda
July
next time
meeting.
and get those guys here. Okay, any other discussion on that? Hearing none, all those in favor say aye.
Aye.
Opposed?
Aye.
Motion carries. It was showing one nay vote. Okay. Now, Vicki, you got another question.
Under the timeline, and I know they send letters currently, I know that's but as the mail gets further and further out, I mean, I can name multiple situations in my daily life that people have mailed checks and 30 days later, they have never seen the light of day. And so, I don't know what the answer is, unless it's sent by certified mail, which I know costs money. But this is
And I
saying
think they
from the
are.
day that the letter is sent, and it's like,
I think it is certified. Yeah, they are certified.
okay. I didn't think it was, based on something that occurred to me with the city a long time ago.
With your zoning enforcement issue?
Yeah.
Hope that paid out, but we actually do both, we're certified and uncertified.
Okay.
Yeah, because a
Then
lot
that
of
makes
times
me
they
feel
put
better.
down Certified and they'll take it.
Had to shut her down.
No, that's a good point, Vicki, with the
I mean-
mail. Sometimes you just don't, especially in the country, I might not
Yeah.
get mail for 3 days.
Yeah.
It just happens.
David, where, just as an informational item, where does this start? Does a citizen call the APC office to file a complaint? Where does that begin?
Yeah, they can call, they can email, they can walk in. Any of those things. We'll have a link on our website to file a complaint, which I think Mike has right now on his website. I imagine Paula will get a lot of phone calls and have to direct them down to us. She's kind of the recipient of a lot of incoming stuff.
It's a very simple form to complete.
But it is a written request signed by somebody, so it's not an anonymous.
Exactly.
Right.
It almost has to be that way with that too much anonymous.
Okay.
But we, like commissioners, have signed some. I just signed one yesterday. Well, I think this is a phenomenal idea, and like Gary alluded to, this shift to enforcement being done by the building commission was done largely due to a personality conflict, and then it was just not looked at all these years. And I think when David suggested this, I thought, yeah, that's a great idea. This is why it's such a benefit to have a fresh set of eyes on these type of things. So, yeah, I think this is a great move, and I appreciate you and Mike working through this and moving this forward. So do you want a motion to move this forward?
In a second. I got
Okay.
one more comment, and I'm not sure if it's in this, but I think in the ordinance, there's something that says, and maybe that's if legal action is taken, and the violator loses, they have to pay the county's legal expense.
Right.
Right. So I once again was opposed to that in like 2003 when it was passed. I just think it's burdensome or one-sided. Why would it not be the winning side get their court costs paid? Or, just like any other legal action, this is a benefit to the community, and so the community should bear the cost of doing that. I mean, there's fines involved. It's just one more, seems like, hurdle that the citizen may have to overcome just to have their case heard. So once again, I'll throw that out for consideration. I don't even know, is that legal? I mean, it's in the ordinance. Maybe if nobody's challenged it, are there court cases that?
Yeah, I would say that it is a very standard provision to have the plaintiff, in this case, the person who's pursuing the action, have the right, if they prevail, to have the attorney fees paid. Because attorney fees are not going to be paid if they lose, okay? Courts always have discretion in these kinds of cases to grant or not grant, even if it says it. Judges are going to often, for whatever reason, say, no, we're not going to give you attorney fees in this case. So by putting it in there that the county gets the fees, it still has that judicial oversight where they go, well, we're not giving you fees here, counsel, sorry about that. And that's purely the prerogative of the court. So the way it's set up right now is the standard across the board. There is also, in a contract where you have two parties who are negotiating, and the reason they have it turn out a little bit more even-handed is because two parties are negotiating, and they say that a prevailing party will receive attorney fees.
Maybe that's
Now,
where I get that from. That's
and that is the language. It's
that I
common
see.
language in contracts that are negotiated. And what's interesting about it, it almost results in the same thing. Because the judge, even in the case of the language we have right now, the judge isn't going to give attorney fees if the county loses. That's not going to work. And the judge is not going to go along with that. Because the judge is going to say, look, county, you have the right to get your attorney fees if you enforce this. You didn't enforce it. You lost. And so it almost gets to the exact same spot. And the only difference is, in our case, in the language we have presently in front of us, you are assuming that the judge is going to do as I have just designated, which has been my experience for more than 30 years. If you lose that case, you're not getting attorney fees.
Okay, I got that. What about when the case is heard
Yeah.
by the BZA? You don't have a judge involved.
No,
You have
there are no attorney fees at that level. It's only if you get to the next level after that.
Well, I'm not
I don't
sure if
believe
that's
the-
correct. but-
Do you know whether that
'Cause I think
has it
we-
at the ABZA? I don't recall that being.
Because I think we charged them on the last case where.
The area
there's-
Board of Zoning Appeals. Yeah, it would have to be in a lawsuit. So in other words, so I'm looking at page 13, and it's right past halfway in the big paragraph. It says, "The area Board of Zoning Appeals may recover reasonable attorney fees, court costs, and other expenses by appropriate suit at law."
Okay.
So what would happen is you always have that intervening court action. So,
Well, to read, at least mine says, area board of zoning appeals or the administrative officer bringing the action
yeah,
may recover reasonable attorney's fees, court costs, or other expenses of litigation, appropriate suit at law.
Yeah.
Owner, okay, so if it's held in front of the BZA, those fees would not be appropriate, attorney's fees would not be appropriate.
Correct.
Okay. They may have been incorrectly imposed, maybe
Oh,
on a
maybe.
previous case. So anyway, I'm fine with that.
Yeah.
If it goes to court,
yeah, you
that's a
got to
different
go
deal.
to court to
Okay.
get your attorney fees.
I'm
It's
comfortable
an
with
extra
that.
step.
I'm comfortable with that. Okay. Any other discussion?
So can we send this forward to full APC, or do we first need to have the bylaws
I
made
think
to
you said that the
consider?
bylaws committee has
I know.
first pass at that.
So in other words, my question is, does that committee need to meet and move on that action before we can move this forward? No? Okay.
I'm not hearing that anybody wants a change in language here.
Okay.
So we'll bring forward an amendment to the bylaws next month, dealing specifically with the fee.
Fee schedule.
The-
Yeah,
the-
good.
Okay.
Oh, just on the fees, yeah.
Yeah.
No, I think it's good, and I hope it works as well here as it does in Johnson County, and I know Mike does too, for, in his previous predecessors. So hearing that, we will take a
Okay.
motion.
I'll make a motion, we move this zoning enforcement amendment to the full APC.
Second.
Motion and a second to move this on to the full APC, positive recommendation. Any other discussion? Do we need comment from the public? Is there any comment from the public? I see we have some administrative officers out there. I say, anybody have a comment on this? I see you shaking your head, yes, that's a good sign. So, hearing none, all those in favor say aye.
Aye.
Opposed? Very good. I think that's a good plan. Thank you for putting that together. Next, creating 2 new zones for townhouse developments.
Okay. Well, we're getting creative here. We've been tinkering with this idea for less than a year, probably late summer, fall of last year, raised this issue. This has been something on my mind for a long time, about trying to achieve a set of zoning districts that allow for the by right development of single-family attached homes, or townhouses, row houses, whatever you want to call them. So these are, by definition, which is something that I would include with this proposed zoning ordinance amendment, it's a single-family attached home on a fee simple lot. So it's not condominium property, it's not horizontal. You own the dirt, you own everything between you and your party walls, going vertical. You have a lot, and then you have a building that's on it that happens to be attached via party wall to a neighbor. So we obviously have examples in town of this, and it's a very traditional urban style of development. We have some lovely examples right here along in downtown, especially across from the library. And then we actually have some new projects that largely have accomplished this through the plan development process, because we can negotiate standards there. And the objective is essentially, it really is rooted in affordability, creating home ownership opportunities for folks that maybe can't afford the single-family detached home, even on an R1B lot. Perhaps they can afford a single-family home that happens to be attached to their neighbor. Obviously, we have the duplex option. We have duplex zones, R2, R2U. We've had those for a long time, and we have plenty of projects in the community that have 2 dwellings on a lot. But this is strictly a single-family effort. And so a lot of the uses and special uses, buffering standards, signage standards are all ultimately connected with R1 zoning and R1U zoning. So the proposal here that's in your packet is sort of a layout. It's not an ordinance format, because I kind of wanted to just introduce this to you, and my ultimate objective is to kind of give you a month to chew on this, because it is a new zoning district. We are trying to deliver something different, and so it deserves some scrutiny. I can tell you that the development community has been very much involved behind the scenes on this. Both Dan Teeter and Joe Bumbleberg provided comments early on. There have been some local developers that have submitted comments to us, primarily through the connections that Mr. Teeter and Mr. Bumbleberg had. They sent them out to people they knew. We got comments back. And then finally, we actually had the staff at KJG Architecture was kind enough to do a little pro bono work for us, and they actually ran this through a design test. And I think perhaps at the next meeting, I'd like to try to acquire some of their drawings that you could see what they came up with. But we went through a round of comments with them, because we wanted to see if this could actually be, could you build this thing? Could you build townhouses with this? Did we miss something? Did we get some setback wrong or something like that? So KJG sent us comments, and that resulted in a general revision of this thing, which happened kind of over the winter time period. And then finally, internally, the joint staffs, Lafayette, West Lafayette primarily, and the Building Commission were engaged to kind of do a final staff check, before we came to Ordinance Committee. So that's kind of the ringer that this thing has gone through already. And so really, the objective here is to try to just get additional comments. And believe me, if this is the first time you're seeing it, that's why I'd like to, continue this another month to give you a chance to look at it, share it with folks that you know in the development world. I'm going to be doing the same, so that we can get some feedback. We want to try to make this townhouse, we want to make this tool useful for the community. And so I want it to reflect those desires. But it has been largely based on the work done with these projects. The Providence plan development, there are townhouses that are already in the ground now. They've not been final platted, but the buildings are there. Chad's overseen that form-based code had a townhouse-style project with very strict development standards. And they're sort of listed here, about what you can do and the general building alignment and footprint and height and all the rest. The Catherwood plan development is largely completed. It's at Happy Hollow and River Road. If you haven't been by there in a while, you should check it out. The first stick of townhouses was built just before the Great Recession, and then the project went dormant, and then it fired back up again, and they've largely completed everything. Slightly different style from the original design, but that PD had a lot of flexibility. Again, West Lafayette oversaw that project. The Centennial form-based code, we have not had any projects develop under it, but it was largely based off of a CB zoned project that I'll go through as I go through these slides, that on 5th Street, the 5th Street brownstones, or whatever you want to call them, that the neighborhood association there had raised the money to do this development, create, I believe, 10 or 12 units on that half block, and then sell them. And it was wildly successful, and the units have only increased in value. We largely wanted to make sure that that project would be by right, that it wouldn't need variances necessarily if somebody wanted to replicate that look. And then finally, the Discovery Park form-based code also largely borrowed from the Providence form-based code that's built into the Providence PD. And PRF would have the option to develop townhouses in there.
Hey,
So,
Brian,
yeah.
what does ground floor transparency mean?
That means you have a facade, say west facade. How much of the area of that facade is window? So transparency just simply means windows.
Okay.
It's a common term used in form-based codes, that there's transparency there. It's essentially, and this is largely in form-based codes where you're trying to achieve a certain look, that you don't just have blank facades on all the, that there at least has to be some percentage of windows there.
Okay.
And for some of them, it's a very small percentage, like maybe 25%, and they can throw a few transoms in there, and it looks, it punches the ticket.
Okay.
And on the Providence side, these standards are for their single-family detached, which they have more examples of those in Providence. And they've largely, like I said, Chad's sort of overseen that. They've created their own checklists to make sure all these little items are accounted for as they go through the design. But just some real-world examples. Here's Catherwood. This was the original stick of townhouses. There are 3 stories on this one. The subsequent buildings that have gone up north of Catherwood Drive have been of the 2-story variety. They're all rear-loaded garages on the ground floor that have common driveways that they connect to, and then these driveways connect to the public streets. So they're rear-loaded, so the front doors are in front. They've got front porches that walk out onto the sidewalk. Very urban, but very low scale. I mean, these are 2 3-story buildings, fairly small lots. I mean, they speak for themselves when you see them. So, but this is an example of earlier aerial photo of what they look like. The Centennial Project that the neighborhood developed. This is a site plan the city of Lafayette delivered. This project was able to occur as a matter of right with some variances in the CB zone, because the CB zone essentially has 0 lot line. So you can essentially do a townhouse type project, although that's not really what CB zoning is for. It's mainly a business zone and a mixed use zone. But they were able to utilize the ordinance for their purposes. And that was part of the reason why, there should be a district for this. We shouldn't have to zone something central business and then do a zillion variances and commitments just to get the townhouse. Why not just have a townhouse district? So this is a case in point here. This is obviously would, fit in a much more urban aesthetic, on the street grid, rear-loaded off a public alley. So that's an example there. And then the aerials. If you haven't been by 5th Street in a while, you can check them out. You can't see the backyards because their garages are kind of in the way, but you have a little bit of privacy yard in a very urban setting. This is the Providence project. The townhouses are going in off of Harrison. They have the option to do other townhouses, and they are planning on doing so. But I think they wanted to build kind of few specs and see if it takes over there. The ones that they build are 3-story variety, fairly small lot, and they were wavering on deciding whether they would just sell what the building footprint and then let the HOA take care of the rest, or actually create a larger lot outside. They decided for the latter, so the neighbors will have yards they'll have to care for per the HOA. And then these are just some of the building plans. And then the facades. Form-based code is, here's an example of the transparency issue there, where they had a certain percentage they had to make on the side units, or the sides of the end units. And so they got windows in where they could. And then these are also 2-car garages, rear-loaded off alleys, with front doors dumping out onto the sidewalk. So, I'm not going to necessarily go into the nitty-gritty here, but the objective is ultimately to create a definition in Chapter 1 to really govern a single-family attached home, and then split the townhouse option to a Type 1 or Type 2. That terminology will go away when we actually draft the zoning ordinance language, we're going to use the terminology R1T and R1TU. So a U district version for the urban sewered maps, which I think we're all familiar with after the saga with the self-storage business. And then areas outside of U districts would be eligible for the R1T zone. So we're essentially trying to create an urban and essentially a suburban standard. The suburban standard is more akin to Catherwood, where the urban standard is more akin to the Fifth Street, much more tighter, right off the grid, so to speak. So those would be the two proposed district titles. Primary uses, special uses, accessory uses, all of those just go right from the R1 and R1U zones. Again, this is a variant of single-family residential development. So in our opinion, the uses that are permitted in single-family homes, single-family detached homes are applicable here. Albeit, some of them may have, given the design limitations of a townhouse, the odds of a church going into a townhouse pretty slim. But these are the uses that are permitted in those zones. So that was sort of my starting point. We're free to obviously go through all of this and over the course of the month, or longer if needed. So we address minimum lot area, minimum lot width, fairly standard, issues in conventional zoning. We didn't establish maximums necessarily, except in a few areas that are fairly typical: maximum lot coverage, minimum vegetative coverage, and then the setbacks. These are much smaller lot environments, and especially with the urban ones, we wanted to make sure that there was some plenty of room in order to design in a very urban, close to the lot line development style. So we provide the setbacks for the various arterials and collectors. And then we establish also a maximum setback along all street frontages. The purpose of a townhouse is to be closer to the street, even in a suburban context. Like if you take Catherwood, given the right-of-way limitations, that project is set back, 25, 30 feet from the sidewalk. So there's a lot of landscaping in front, but it fits. But we felt that pushing something even further back, you really lose the whole point of having the townhouse. So we felt like establishing some sort of maximum setback made some sense. And then, of course, the rear setbacks, the sides. And then we discuss the minimum setbacks for townhouse groups, this section here. And this is something where I think we'll get an illustration from KJG, because I kind of went through this with them. And the objective is to not have an unbroken wall of townhouses that is just kind of dominates the streetscape. So having some architectural variation, so a unit might be set back a little, one might be pulled forward, that there's a way to try to create this kind of, probably the best description is, or best illustration is what Providence is doing. You'll see here, let me go to their first floor. So you'll see here it varies where they have a front porch, and then there's a variation here where this unit is sort of pushed forward and sort of has a much more generous garage area, and then it kind of fluctuates. So there's some variety, and you don't have just this, every unit's the same, and it's an unbroken wall of architecture. That's the objective. We're trying to create a little bit of variation. Now, this is just a minimum standard, so obviously in the Providence's case, they went pretty far because they wanted to create big porches for every other unit. That's up to the designer if they want to do that. We just wanted to at least have a minimum standard. And what I found in my analysis is that 2 feet seems to be the standard a lot of them go for. So that's what that stands for. Other things to review that are kind of not typical is how many townhouses can you have in a group? Well, it's meant to be an attached environment, so the minimum would be 2, you know? So essentially you have, you know, 2 lots, lot line running through them, they meet at a party wall. You essentially have 2 end units abutting. We felt that that's the absolute minimum, otherwise it's a single-family detached home and it's really tall and skinny and, you know, kind of looks silly. But then also per building code, you can only have so many units before you need some sort of break for the firemen to be able to run around the back. And my understanding from building code, and you know, is usually 10 seems to be the maximum that you'd need in order for there to be a break. So if you're in a more suburban environment and someone's building townhouses, you know, they can't just have, you know, 50 units, even if they're undulating every 2 feet. There needs to be some sort of break, otherwise the fireman's got a long way to go to get around the units. And so this is sort of playing into building code limitations as well. The other is minimum architectural standards, and this is very much left up to the AO's determination. Again, we're trying to prevent monotony with these districts, and this is sort of the only area where we kind of touch on architecture a little bit in terms of style. And so we came up with this terminology to try to address, you know, abutting units not being substantially the same. So obviously left to some interpretation there. And then the building height, you'll see it's 45 feet. That's sufficient, according to KJG, for a 3-story unit. If you go to 4 stories, you need an elevator, so we didn't want that. So, but you'll notice that we don't have a minimum. We're not, if someone essentially wanted to create a single-level townhouse, they could. And architecturally speaking, we have a project in town that looks like that from the street. The Redwood project on Twickenham are single-level townhouses in their development. Legally, it's a multifamily complex, but it's arranged from an urban form as unit attached to unit attached to unit, and you know they're all single-family units essentially. That's the way it reads from the street. So this would allow essentially a you know, first floor only, 2 or up to 3. The exceptions are standard from the R1 for, you know, church, you know, steeples and, you know, things like that that probably aren't applicable here. We are doing a lower parking ratio for this type of unit since it is sort of a unique type of design, and it's just a minimum standard. So if someone wants to provide more than 1 space, they can, but they at least need to provide 1. And then we're very flexible on the parking for both types, and we have some language here that we've battered around a lot, but it's basically we want to maintain that rear-loaded environment. Front-loaded townhouses create a terrible situation from the street where you have a bunch of curb cuts right next to each other because the houses are a lot closer together. And it really disrupts the sidewalk network, the streetscape, because you just imagine you have a bunch of curb cuts dumping out onto a public street. There's safety issues concerned with it. And so we are essentially trying to create just rear-loaded only. And the examples I showed you sort of demonstrate the suburban type, like in Catherwood, and the more urban type when you have public alleys to work with. We have examples of this in action, so this is what we're essentially trying to foster here. Signage and buffering requirements are consistent with R1, but the other parking issue is that we're actually promoting the idea of allowing off-site parking in the event that a developer wants to create a garageless unit and have a parking area within a reasonable walking distance, either on site, say it's a suburban environment and they have a surface lot where all the common parking goes, well then that would allow him to build townhouses without garages, you know, because the parking's accounted for there. Or in an urban environment, developer wanted to build townhouses and he's got access to a garage or some other facility nearby. That seemed reasonable in our estimation. And so we're doing a little bit of innovative thinking here on the parking issue to try to be flexible for this specific type of use. That's kind of a general overview. Like I said, where we go from here is I'd like to at least table this a month and give everyone here a chance to chew on it and send in comments, or at least have discussion points ready. And then, I'm sort of reluctant to organize this into ordinance format until we've got a lot of these fundamentals ironed out. But that would be the next step, is to actually have it available in full ordinance format, R1T, R1TU. And go through those, and as well as the definition that we would like to add when we finally get to the end of this discussion. And then on my own, and then on your own, I'm going to be sort of sending out all points bulletin to all the developers that have been working with this. There's some of them that are very interested in, I think, using this tool. And that's ultimately what we're doing, is essentially just programming the tool in the ordinance and then letting the developers decide if they want to trigger it. If the localities on their own or the APC itself would like to, promote this in some way, and if there's areas in the cities that, or even in the county, and this, if it's on watered sewer, these would be that would be one requirement of this zone. Proactive zoning, that's certainly available to the localities if there's interest. But that, I guess that basically concludes my presentation. So if there's any questions or initial reaction, otherwise you guys can think about it and we can talk next month.
Can you email out your full presentation?
Oh, sure.
Yeah.
Yeah. Yeah, if you want to see some of these,
Yeah.
I'd be happy to do that, yeah. And, and I encourage you to visit some of these areas in the interim and kind of get a feel for it, walk around it, see what we're trying to achieve. But we ultimately feel that this is a sort of a missing middle in our options for residential housing. We have single-family detached, we have duplex, we have multifamily, but we're missing something between duplex and single-family detached, and that's single-family attached. So we're trying to see if we can fill that gap. And I think if this is employed properly and is developed, I think this will provide housing options for the community we don't have right now.
So, and some of these are multiple units, right? Some of them have a basement unit. That's
Sure.
Yeah.
Yeah, you'll see we're silent on basements because it's up to the developer if they
Okay.
want to put one in, yeah.
And how was the 4th Street project done? Was it a PD?
The Fifth Street? one?
No, 4th Street. It is 4th Street. Yeah, the one kind of.
In Centennial?
No, on 4th there. The brownstones there.
Oh, those. The new condos.
Yeah. Those
Yeah.
are-
That was essentially built as a multifamily building.
Okay.
Under CB zoning.
Okay.
And it was outside the courthouse proximate area, so you could build a multifamily structure. So they just built by right a multifamily structure, never rented them out, and then came back in with the condo conversion.
Okay.
Which is now platted and they're for sale.
Okay.
So, yeah. And those is sort of a variant. When I worked in Northern Virginia, we had townhouse districts where they called stacked townhouses, where essentially it's like 4th Street, where you have a unit on top of a unit. And we have an example of that as a PD on 5th Street across from this project, where you have two units stacked, and then there's steps that go down to the bottom unit, and then steps that go up to the top unit. So I wasn't quite ready to go there. We can go there later if you want, but let's see if we can get just a standard townhouse done, and then if we want to create a stacked district, we can. Those would be even more affordable because you're, shrinking the footprint. So I'll email that out to the group.
Okay.
And one thing to note is, this, apart from creating the definition, which would be in Chapter 1, this would be in addition to Chapter 4. So, variances could be achieved for really any of these things. So if someone does have a unique situation where they can't do this or that, they could seek a variance. So that's important to note.
Ryan, in your contract group, I assume is it the local building or Bagel building? Have you?
Yeah, I've reached out to them, and so now that we kind of have something in more finished format, I'll reach out again. I know there were a few developers that specifically were asking about this, and so they're definitely on my Rolodex, so to speak.
Very good.
So.
They just seem to be a little more active than they used to be, or organized than
Right.
they used to be.
Yeah, and there may be interest in this, yeah.
Very good. Any other comments, questions? Otherwise, very good.
Thank you.
Good idea. Citizens' comments. Please, okay, great. Please come up and,
I'm Mary Ellis, Builders Association of Greater Lafayette Executive Director. I attended today because of the Townhouse ordinance. We're very interested in this, and I would request that the Builders Association of Greater Lafayette be included in all documentation on this. I will take it to our developers group in a couple of weeks. Thank you.
very good, I'm sure.
If
Yeah, I can
if
forward
you're
it to
interested
you.
in me making a presentation, I'm available.
That would be great.
So just let me know. Okay.
Great, Ryan, because I know Ryan wants some feedback. Yeah, good. Any other citizens' comments? Not taking any grievances today, doesn't look like, so on to that last motion. Somebody would move to adjourn.